good morning, and hopefully we'll be done when it's still good morning for all of us. We're going to talk about pilot deviations and FAA enforcement actions. And just to start out, let me tell you who the heck I am. I'm new to the Raleigh-Durham area. I moved here from Colorado at the end of 2012. I'm a lawyer. I'm a commercially rated pilot. I'm an instructor, single engine only, and instrument. I'm licensed in 3 states. I'm a member of the AOP Legal Services Panel, Lawyer Pilots Bar Association, and I'm also a member of NBAA. All lawyers have to have disclaimers. I think by the time we get to the presentation, you'll have some idea why the disclaimer makes some sense. And it's because it's more art than science, and what you're going to do in a particular situation depends so much on what the situation is and a number of other factors. So don't say I didn't warn you. You can't take any of this stuff to the bank. How does this all start? You land at RDU and the tower comes on and says, after landing and you roll out, give us a call. Here's a phone number to take down. Or you may be flying IFR or even VFR and you hear magic words from the controller saying possible pilot deviation, suggest you contact, and then take down a phone number. You may receive a formal letter of investigation from an inspector of the FAA. You may be the object of a RAM check. It may be in the course of an accident or an investigation, whether yours or somebody else's, and you never know what's going to happen. I had a friend of mine who was taxiing on a runway, taxiing on a taxiway between 2 runways. Somebody else decided, an instructor decided the best first lesson for a multi-engine pilot was to do a single engine approach and go around. The result was loss of control. The multi hit my friend's 182 while on the ground taxiing, and my friend described his involvement with the FAA as, I felt like I did something wrong. Okay, so you never know what's going to happen. Sometimes complaints by citizens, flying too low, people calling up over some ritzy neighborhood and calling with a noise complaint, and if they could read your tail number, you're probably too close. And then, of course, other complaints by other pilots and operators, and that's particularly true in those areas where they're talking about a private pilot who may be exceeding private pilot privileges and moving into Part 135 territory. A lot of those complaints come into the FAA by Part 135 operations that see this guy in his 172 picking up passengers all the time, and they all seem to be different people. You got your initial contact, call the tower, possible pilot deviation. Now, the possible pilot deviation, has anybody ever heard that one? Whether in the air with somebody else? That's typical in the IFR world. If there's an altitude bust or a heading bust and there's been a loss of separation, the controller will, at the earliest opportunity that they can, advise you, this is a possible pilot deviation, suggest you contact, and they'll give you a phone number for approach or for somebody to contact on the ground, usually the TRACON facility or the center facility, depending on whose airspace that took place in. It's called the Brasher warning, and that's because of an old case from the late 1980s. The warning has been in the ATC handbook for a while. In Brasher, you had a pilot who had an altitude deviation, and they didn't give the advisory. And the NTSB, looking at FAA materials, said, well, that warning, all the FAA materials say the warning is so that you as the pilot know at the earliest possible time that somebody thinks you had an altitude, basically a separation instruction deviation, and gives you an opportunity to sort of look at your stuff, look at where you were, and kind of prepare a response. Not to make the response then, but so you at least know that you're being looked at the earliest possible time. And what they said is that in this situation, the violation doesn't go away, but if they were going to, for example, issue a 30-day suspension, there's not going to be the suspension. And there's been a couple of cases since Brasher upholding it and then saying it doesn't apply to certain other things, that it's really about separation kinds, airspace separation and traffic separation kinds of instructions. And so, for example, the runway incursion does not require this Brasher warning. And there's a... So the question is now, what do you do and what do you say? A friend of mine, when I said what the topic was, he said, this is the answer. and I wish it was, because then we could all, finish off the coffee and donuts and go home. But unfortunately, it's not as simple as just zip up your mouth. The problem is Many times saying absolutely nothing, not making that phone call, will be the right answer, but could also be very much the wrong answer. And we'll talk about that a little bit, but just so you're aware, the FAA has a number of different ways in which to handle possible violations. You have a number of ways to handle possible violations. So let's go and take a look at what these are. One, you've got the general enforcement process, and this is actually, the first time I gave this, I had one that filled the screen with about 40 different little sections and all that, and I said, here's the nice simple process we're talking about. So this is sort of brought down. You have an event, you have informal investigations, and that's, that's the point at which the tower asks you to call them, and maybe you just talk about it, and that's the end of it. Formal investigations, which usually involve something we'll talk about, which is called a letter of investigation, which is the FAA formally advising you. Anybody here get one? Anybody here want to admit to getting one? Okay. And then in terms of what they can do, there's a series of administrative ways of handling the case before it gets to the enforcement world. One is nothing happening. Another is something called administrative actions, which aren't considered to be enforcement. The dreaded 709 ride, and then at some point maybe you get proposed certificate action where you get a letter from an FAA attorney and says, we propose to give you the following penalty, what do you think about it? Once we get into the proposed certificate action area, you have your choices. You can simply accept it. You can ask for informal conferences with the FAA attorney, which actually do something. I've seen cases being dismissed at that stage, even once they start. From there you go. If that doesn't stop the process, you have a hearing in front of an administrative law judge who's a member of the NTSB. From there you have appeals to the full NTSB, and from there you go from the appeals to the courts. I assume everybody here somewhere along the way has heard of the Pilot's Bill of Rights. One of the things that the Pilot's Bill of Rights changed was what that appeal to the courts looked like. For a long time, it's been straight to the U.S. Court of Appeals, which is daunting even for lawyers. Now it's either to the U.S. Court of Appeals or to the federal district courts. So you can get into the district court, let's say here in Raleigh, or whichever circuit you're in. So you get this letter of investigation, and for anybody who's seen it, they've seen that language in it. It says, respond in 10 days or the file will be processed without the benefit of your comments. Even at that point, it's a tough call. What you're looking at when you get a letter of investigation, you're looking at the initiation of a formal enforcement process. Does that mean that that there's going to be enforcement action? No. It just means that they're taking the formality of the process. And this is really the first place that I talk about if you get the letter of investigation, that's the time to speak to an aviation professional. And obviously I'm going to say that means lawyer. And if you're on the AOPA Legal Services Plan, that's what you're using it for. It's using to get that consultation. And sometimes it's going to go no further than a consultation. It doesn't mean, as a lot of people think, that some great lawyer is going to come in and say, I never lose, I'm going to kick the FAA's rear end and all that. That's not going to happen about 90% of the time. If you're lucky, 10% of the time you might be able to kick the government's ass every once in a while. That letter is going to tell you what the nature of the violation is, and it's also going to give you information about the Pilot's Bill of Rights, which will tell you that you're entitled to a number of things. One, it's going to tell you that you're entitled to air traffic data. That means if, let's say it's a runway incursion, not a runway incursion, but let's say it's an airspace incursion. You were flying too close to the Class Charlie, you didn't meet the two-way communication requirements, or better yet, Charlotte. You're flying past Charlotte, you're in flight following, you impinge on the Class Bravo airspace, Charlotte controller comes on and says, oh, you just got in, you better turn around and get out. You weren't cleared into Class Bravo. 3 days later, you get a letter saying, we're looking into an investigation for a possible airspace incursion in the Charlotte Class B. You're entitled to the air traffic data, the communications, any radar tracks. And what's even better, and this is directly out of the Pilot's Bill of Rights, once you make that request, the FAA can't take an action against you, probably with an exception of emergency action, can't take any action against you for 30 days after you receive the air traffic data. And I've actually seen cases end with a request for air traffic data. A friend of mine was accused of a runway incursion at an airport. He gave me a call after he got the letter. We worked together on a response, and I said, first of all, ask for the air traffic data. What they did was they issued one of the administrative actions we talked about, and that was the end of the case. It will actually tell you that a response is not required. And under the Pilot's Bill of Rights, it will tell you that anything you respond to can be held against you in a later enforcement action. There is, at this point, rarely a reason to respond unless you speak with somebody first. Somebody who's on your end of it to give you, and part of it is legal, and legal is more art than science anyway, but part of it is legal, part of it is experience with the system, part of it is a sense of what works and what doesn't, and part of it is having a third-party neutral in your corner who doesn't have the same tendency that we all have when it involves us to keep talking until we finally bury ourselves. That's, which happens all the time. Only respond if you're sure it will help. I mean, it's kind of like, the suspect who comes in, and if you watch, my wife and I love crime shows, not the made-up ones, but the semi-made-up ones that usually involve spousal murders. We really like those. And I don't know why, but you have, usually have the accused, you have the remaining living spouse in the hot seat, and you sit there and go, stop talking, call a lawyer, come on, stop talking. And they just keep going and going and going because they think it's going to help. But at that point, they're a suspect. And once you're a suspect, you're always a suspect. We went through the process. Now we have what the options are. Well, the options we talked before, there's no action, a warning notice or letter of correction, and we'll talk about some of these as we go along. The dreaded 709 ride, certificate suspension, certificate revocation. And I put it in brackets because we're really not going to talk about it. But the FAA, sometimes the question comes up is, I don't have a pilot certificate. What can the FAA do to me? Well, they can fine you. And that goes for, and they often, and you'll see fines sometimes talked about in the news where it's usually some airline that gets tagged with a fairly large civil penalty, quote unquote fine, because of for some violation of the regulations. But in theory, it could happen with pilots also. The FAA typically doesn't do it very often because our pilot certificates, if we're an active pilot, are more important to us. And so they figure there's enough sanction involved here if you simply do a suspension of a pilot certificate. No action. No action can happen at any point. Okay? It could happen down the line. It could happen after a talk with the controller. Oral written communications with an inspector. True story. Some years back, I used to fly for 20 years out of Denver Centennial Airport in the Denver area, which is the second to third busiest GA airport in the country. It flip-flops with LaGuardia on total number of operations. I did an Ordo landing without getting anything. No light signals, no nothing. I was doing a discovery flight of all things. And I had a potential student, and all of a sudden our radio started going completely haywire. And when you could hear the local AM station over your VOR, you know you've got some kind of an issue. And I decided, I don't know if the next thing is going to be, what's that smell? And so I decided to come in, couldn't communicate with the tower. I tried the tower flyby. I went around a couple of times, trying to get their attention, nothing. Finally, I knew what the last report was of what the traffic pattern was. It looked like the area was clear. Came in, landed, taxied off, waited for a taxi light signal, nothing, just went back to the FBO, and then did the thing I would never, ever, ever recommend anybody does, which was I called the tower and say, hey, that was me. The next day, I get a phone call from an FAA inspector. I told the inspector what had happened, and he goes, let me talk to my supervisor, give you a call back this afternoon. And so I said, fine. He calls me back in the afternoon, and he says, well, write up and send me a letter describing exactly what you told me over the phone. And we'll throw it in the file, and that'll be it. And in fact, that was it. So, when I talk about that this is more art than science, that sometimes contacting is the right answer, it really, really, really is very situation dependent. If there's no action taken, the record goes away in 90 days. It just disappears from the file. And I've seen that, like I said, I've seen it where, in my own situation, where it's been at the most informal levels, and I've seen it also. I was representing a Part 135 pilot who had a flame out in IMC in a Class Bravo airspace. And it wasn't until we got to the level where we're having an informal conference after he had been quote unquote charged, having an informal conference with the FAA attorney, and the FAA attorney at that point closed the case. Warning notice of letter correction. This is one of the administrative dispositions that they can do that doesn't involve the FAA certificate action. It's called an administrative action. It's not called an enforcement action. And it typically involves retraining. And sometimes special FAA programs usually involve some kind of retraining. This is very often the result, well, when this is done, it is typically going to be the result of somebody who's contacted the FAA, who has actually responded to it, to a letter, to an informal inquiry, or even a letter of investigation. Warning notice, FAA decides, usually involves retraining, discussion, and all that. Again, describes the and say there may have been a violation, and they put that away, and just put it in your file. Nothing. That's what ultimately happened with my friend's runway incursion. When he asked for the tape, when he asked for the tapes and they never produced them, they said, "Oh, we'll just issue a warning letter and go on your way," and that was the end of it. The letter of correction is very similar. There's a violation. Here's some corrective action that you could take, because we've decided we're not going to take formal enforcement action against you. We want you to get trained in this area, this area, this area. The pilot agrees. If the pilot doesn't follow through, then the pilot is in really deep water. And it may even be at that point an emergency revocation, and that's one thing you never really want to get into that situation. The 709 examination, the FAA has the authority to re-examine an airman, and it says at any time, has to be reasonable. I'm unaware of any case which has ever said that the request was not reasonable. It's supposed to be a limited request, so that if it was a gear up landing that resulted, that was the trigger for the 709 ride, you're probably not going to be asked to do turns around a point in the practice area. I have seen 709 letters, though, where they're saying basically we think you're incompetent as a pilot and we're going to retest you on everything. They are to some degree negotiable. And the thing that's most important for a lot of people in the negotiation of it is they can ask for a change of FSDO. That, whatever reason is, and a lot of those simply are because of location. I mean, if I happen to be flying to Florida and I run into something and they say I want to do a 709 letter, I probably want to get it transferred over here where I'm home. I don't have to go down to Florida and again, in order to take a check ride with an FAA inspector. Get and log training, and actually that's going to be a recurrent theme for a lot of this stuff. Is that if you're going to do a 709 ride, obviously you want recurrent training. If you think it's a situation where recurrent training with a letter of correction or a warning letter is going to make a difference, be proactive about it. Get with an instructor. I mean, it's easy enough. Especially if I really loused that one up. You want instruction to correct it. And coming back to the FAA as part of a discussion scenario and saying, look, I've already started. I've taken 5 hours of dual. We made sure I got my gear procedures correct in this retract is going to make a big, big difference. There's this concept called compliant attitude, and that's where I'm not in the group of lawyers who say, oh, never talk to the FAA, because so many times it's going to make the difference of talking to them. The FAA, as much as we like to think otherwise, the FAA isn't really there to bust your chops. The FAA is there with their primary mandate being air safety. And yeah, they got to bust people's chops once in a while, just like any other enforcement agency does. But if they have an alternative that doesn't involve the necessity for enforcement, and that's going to be, who's the inspector, how do they feel about it, are they a cowboy? I mean, just like regular police officers, there's good and there's bad. There are those who are considerate. There are those who abuse their authority. They're all over the place. But there are things you can do to sort of help your situation, and if not, you just go to the next step. Suspensions. Suspensions tend to be for a stated period. Your pilot certificate is suspended for 30 days. turn it in, surrender it, and 30 days you can go and get it back. There's a whole FAA order. You can look for it online. It's 2153B. It's the FAA Compliance and Enforcement Program Sanction Manual, and has a sanction guidance table. You can go through the table and say, oh, for this kind of operator, this kind of violation, here's the recommended penalty. If you're familiar with sentencing guidelines for some reason in the courts, it's the same kind of concept. Expunction. We talked about, you know, the 90 days if there's no action taken. It's 2 years if it's one of the administrative actions. It used to be 5 years for the record to be sealed and expunged. And then we had the Colgan crash, which led to so many different changes in the way, and the most current one that most people think about is the new ATP requirements. But one of the other things in there, they said, no, we need to know if somebody has had their pilot certificate suspended ever, if they're going to be looking for a job. And so the stuff stays on your record. Revocation, the most serious of it, that's it. It's gone. You don't get it back. You can reapply. The regs don't say anything about how long you have to wait to reapply. I guess you could theoretically go file your application the next day. But the FAA's rule of thumb on it is that it's going to be denied unless a year has gone by. You start all over. I had a ATP client who was, you know, nailed on a violation and lost his ATP certificate, all his ratings underneath it. When the year was passed, he got his student pilot certificate. And then had to take his private check ride, instrument check ride, right up the line, meaning all the prerequisites. The good news, if there is any good news on that, is that all your flight time still counts. So it's not like you still have to do another, 20 hours with an instructor and another, and all that stuff. You've already met the requirements. Most serious violations of drug and alcohol policies. Fraudulent logbook and other flight record entries and application entries, and repeated TFR violations. And that one has that's always been on your record forever. That's one they've ever gotten rid of. How do we lower the risk of violations? 69% of pilot deviations come from general aviation. That means us. I just got that number this past week. I'm doing an online flight instructor review clinic, and that's one of the things they're talking about. 69% are general aviation. So that's us people. How do you lower the risk? And it's the same kind of things we talk about for night flight or going into an unfamiliar airport. A lot of it is pre-flight planning. I mean, if you know what the airspaces look like, if you know the problems coming up, you're less likely to have some kind of a deviation. Situational awareness. Know where you are. Know what's going on. And it's stuff that's been drummed into us since we were student pilots, but it's something so many of us forget. Taxi diagrams still remains a large deviation issue, and there is no reason ever to not have taxigram. For-flight users, WingX users, other EFB users, they all have taxi diagrams. Some of them even pop them up. You want those taxi diagrams. I mean, they're Charlotte. I mean, I don't know if you want to taxi around Charlotte without a taxi diagram in front of you, but I don't think I do. Especially when you start seeing all these little, these little hotspot signs. And you know what these little things here? Everybody knows what that is? Danger, 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 danger. Pay attention to altitude assignments, especially IFR. I'm convinced altitude assignments is the #1 pilot deviation under IFR. I've handled, very early on, handled 2 of them immediately when I started working on aviation cases. Immediately. One, of course, was the flameout in Bravo airspace, and another one was literally what I described before, somebody putting the roll altitude in the box and climb right through the assigned altitude with a loss of separation. If there's a loss of separation, for anybody who hears that pilot deviation notice, if it involves an IFR altitude and they give you the notice, the chances are you probably don't want to talk to anybody until you talk to a lawyer, because if there's a loss of separation, it will almost always result in an enforcement action. Lowering the risk. Declare an emergency when you have a problem. Okay? What happens when you declare an emergency?
Clear airspace.
There you go. They clear airspace. You can avoid the entire scenario with a declaration of emergency. My client, the flare out. In his case, he had a flame out. He was working on taking care of the emergency, loss of altitude, Class Bravo airspace, in the clouds, and didn't take the 3 seconds to say, N number, blah, 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 declaring emergency. Cannot maintain altitude. Everybody gets moved away. In his case, it resulted in no action. But it took a conference with the FAA attorney, training, okay, flight training, avionics and tablet training. Oh, I have a friend, he bought an iPad, got ForeFlight, was smart enough to ask for a safety pilot, namely me, to fly around with him as he flew those first couple of approaches. And as we were about ready to bust into Class Bravo airspace, I shoved the thing forward because he hadn't taken the time to learn how to use the iPad. Wing seminars, they're great. There was some, I don't know what the numbers are lately, but I remember them talking about numbers some years ago that pilots who go to Wings seminars, not even those who get their flight reviews via Wings, have a much lower accident rate, because the idea is that we're thinking about safety. We're thinking about these things where other people might not think about it quite as much. At ASRS, and there it is, there's our get out of jail free card. It's a safety program with benefits. It's not an excuse program that happens to have a nice website where you can find out information. The primary purpose is safety. It has, and there's that compliant attitude language again. When the FAA bought onto the concept, they said, great, we can get information into NASA. First of all, it'll be NASA, not the FAA, because people won't trust it if they're sending reports to the FAA, so we'll send it to NASA. The idea will be to be able to find trends, be able to make recommendations, and from the pilot standpoint, by fessing up, even on an anonymous basis, you're establishing a compliant attitude and a mindset that's conducive to flight safety. Within 10 days of the incident, doesn't matter when they call you. Okay, they call you on the 7th day, and you go, oh, I didn't file that NASA report. Now they want to talk to me. You can still file that NASA report. Used to have to be by mail. Now it's all online. You get a return, you get a receipt with a number and all that, so you can prove that you actually did it. The report can't be used against you with a couple of exceptions, but they can't be used against you in enforcement proceedings at all. But that doesn't mean there's no enforcement action, because they can get whatever they want from someplace else, so long as they don't get it directly from the NASA report. It's anonymous. That's the beauty of the system. It's completely anonymous. Don't blow anonymity by identifying yourself. You can't unring that bell. So it's anonymous, so maintain the anonymity. Don't say, I was flying, and throw the tail number in, all of that stuff. The only identifying information should be in that one strip if you're using the mail system, which they rip off and send back to you, stamped received. Exceptions to anonymity, criminal activity. I was smuggling drugs from Mexico when I ran into an airspace problem, and here's my report on the airspace problem. No, not only is it not going to help you down the road, but it's also, they're going to say, oh, who's this guy? And send you to the proper authorities. Accidents. NTSB 30 definitions of airplane accidents. If it describes an accident, that also is an exception to anonymity. There is never a reason not to file a NASA report. A couple of misunderstandings. One is it doesn't waive a violation, it excuses the penalty. So, scenario, airspace violation, called on the carpet by the tower, enforcement action started, I had filed my NASA report, and now we come to later stages of the proceeding. It's either at the conference level or even at the level where we're in front of an administrative law judge of the NTSB. I go, aha, I've got my little confirmation that I filed my NASA report about an incident on a certain day, and this is the incident. In that situation, we come in, it's not the judge going, oh, you got a NASA report, case dismissed. It's oh, you got a NASA report, yeah, we're going to put a violation on your record, but we're not, that 30-day suspension, we're not going to give you the 30-day suspension. The waiver of penalty doesn't happen in violation with the prior 5 years. A lot of people think this means that you can't file a NASA report. You only file a report once every 5 years. That's not the case. You can file them every day. You can file them twice a day if you have the runway and airspace incursion at the same time. What it means is that if you have gone through the process, the entire enforcement process, and ended up with a violation on your record, you don't get the waiver of the penalty benefit until 5 years have passed from that violation. No waiver if it's intentional, deliberate, and that's something that sometimes gets argued, and sometimes that's the argument in front of the administrative law judges and the NTSB and the courts as to whether or not something was an intentional, deliberate violation. And it doesn't prevent a 709 ride. 709 ride is not considered to be enforcement action. It's defined as administrative action to just check for, and of course 709 ride, the concept is we want to make sure that you're still capable of doing what you're supposed to be doing, that you're still flying to PTS standards, that you're still a competent pilot, and that's not necessarily something you want to go away just because you file an ASRS report. How do you mitigate consequences? Once something happens, well, one is the aviation reporting system, which you just talked about. Consult before you talk. Sometimes it's possible, sometimes it's not. But when it is, find somebody to talk to. Kick it around. Don't respond right away. Remedial training, talked about that before. Beat them to the punch. I mean, if you've had some kind of a problem and you go, I really I lost situational awareness. I didn't understand what was going on. I think I better get some retraining. Go and do it. Beat them to the punch, because that is also evidence of compliant attitude if you're in the administrative area. Session your own CFI immediately. It can only help and it will not hurt. Go back. What happens? You've got this warning that says possible pilot deviation or a simple call to tower. Hey, this is whatever. It's Seymour approach. You just infringed on the airspace here. And here, take down this number or give them a call. It's kind of informal, not quite a formal investigation. We all know that top line: aviate, navigate, communicate. Fly the airplane, complete the flight, park, tie down. What's the first thing we do when we get out of the airplane after a flight? We go to the restroom, right? Do all that stuff, stop, relax, and think. The fact that they said call the tower doesn't mean you got to do it 5 minutes after you get out of the airplane if you're going to do it at all. First of all, you don't have to call at all. I mean, it's not an ATC instruction like, turn left heading for traffic. It is telling you, hey, we want to talk to you. And so, the first thing to understand is you do not have to call. The question is, the problem is that this sort of dichotomy is, do I keep my mouth shut or do I talk to them? Is that there are consequences to either set of actions. Taking the time to think, hopefully talking to somebody, maybe somebody directly at Pilot Protection Services at AOPA, maybe a lawyer who either is with the legal services plan or not, who just happens to have some aviation background. Talking it out, getting advice can make all the difference. Should I identify myself? There's a case, and I don't know if it's a real case or an aviation myth, and supposedly it's a case in which the only evidence that it was this particular pilot was the pilot calling the tower and identifying himself. And otherwise, without that, they would never have known who the pilot was. Real case, I don't know. Could it happen? Absolutely. I mean, I've seen criminal cases where the only evidence in the case was of identity was the idiot defendant, actually in this case the idiot defendant's lawyer, who admitted that, came up with some explanation of why he was there, and nobody could put him there to begin with. And so, yeah, it absolutely could happen. In most cases, it's not going to make any difference. A friend of mine just recently who practiced some aviation law in Wyoming was telling me the story of a client of his who busted the class Bravo in Chicago. And we talk about the bad place to bust class Bravo airspace. So what he did was he shut off his transponder, shut off his radios, flew around for 3.5 hours, figuring they'll never find me again. Guess what? They found him. And of course, if you're IFR, your name is in the pilot and command block. Unless it was a pop-up, then it might not be there. If you follow VFR plan, your name is there. If somebody from the Greensburg FSDO calls Frank and says, who was flying this airplane at that time? Maybe yes, maybe no. But usually you try to maintain good relationships with the FSDO, and it's something that you're concerned about if you have your renter pilots involved in airspace occasions. They, and in terms of a lot of these, they've got the tapes, they got the radar tracks, they got all this information, and they're in the process of getting it. You can certainly go in and say, I'd rather not say anything. I'd like the opportunity to see the tapes before, and I'm going to actually, that's now wrong as of 6 a.m. this morning. One of the things in the Pilot's Bill of Rights is your ability to get air traffic data. And the FAA, what they did was they set up a nice web page. I don't know if anybody's seen their Pilot's Bill of Rights page, but there's an area there where you can send an email directly to the FAA requesting the air traffic data. As of this coming Tuesday, that page is coming down, that email address is gone. Now it's, you got to wait for the investigating, once you get in contact with an inspector, that's when you make the request. You make the request to the inspector and everything else gets triggered. What I'm saying about contacting is, one, don't do it right away. Okay? Give yourself some time to think, give yourself some time to react, and give yourself perhaps some time to talk to somebody about it. And don't do it, either one, as a knee-jerk reaction. The question was, what happens 24 hours later? Well, if it's something ATC needs to report up the chain, can it make a difference if it's not the 737 slamming on its brakes or something? Can it make a difference? Sure. The talking to may be as far as it goes. It may not be, but so if you have to, if it's 6 hours or 8 hours later, then ATC may have already passed it up the chain. So what you do is, don't ignore. You don't necessarily have to ignore it. And not ignoring doesn't mean calling them. Not ignoring them is saying, giving some real thought and some advice to it. If you do call, don't schmooze about it. If you do call, you want to show a compliant attitude without necessarily admitting very much. Listen more and talk less. Avoid admissions to the extent that you can. Don't threaten to send your lawyer. It doesn't impress anybody. It definitely doesn't. And if you can, speak with an attorney. Speak with a professional, speak with somebody knowledgeable, and if you have the access to it, speak with an attorney. Let's talk about some hot topics. Anybody seen that one before? That's the 30-second segment of a much longer one. There's a fellow by the name of Perker, and it's a big hot case. It's still making its way through the NTSB. It's been to the U.S. Court of Appeals once and back. This is a UAV pilot who is filming this with the permission of the University of Virginia, and was doing it with the intent of selling the video as part of a program, and the FAA, using that civil penalty thing, decided to fine him $10,000. And it's going through for careless and reckless operation and some other stuff. FAA just came out with something fairly new just in the past couple of weeks, and it's for those of us who are UAV pilots who also have pilot certificates. It may not just be civil penalties. If they don't like what we do, our certificates might be at risk. Okay, and so there's a lot of stuff going on. The other big one, on the other hand, is just recently they came out with information on a little more flexibility on first-time inadvertent violations of TFRs, and that includes the CIFRA. The standard has always been it goes straight to enforcement action. There's no administrative action whatsoever. And now there's some new stuff. They're looking at the possibility of remedial training and administrative actions for first-time violations, 1 mile incursion into a TFR area with an immediate exit, or a 2-minute improper squawk for those areas with special transponder requirements, and with no air traffic complications. So they're just giving themselves a little bit. What the document says is that we've been doing this since 2011, and this has been our experience, and we think we can be a little more flexible in the kind of stuff we do. Find a lawyer. Join a legal services plan. AOPA insists that I say something about them. It's cheap protection. I sign up for it. I pay for it every year because I don't want to have to talk to myself. You're more likely to call, if you have the program, you're more likely to call somebody. That may be the worry. We get recurrent training. We have to do it every 2 years with them. And even if you're not an LSP member, if you're an AOPA member, you at least have access to the list. And I know a lot of us who work in this area will do a quick half-hour consultation with somebody, whether they're a legal services plan member or not. And I guess we got a lot of questions during the thing, but if you have any questions, and if not, if there's anything in the presentation that you want to follow up on, please feel free to contact me at either address.